Good morning, everyone. There may be a few more people trickling in, but hopefully, you will you'll catch us up where we're up to. So, good morning and a warm welcome to this webinar, Understanding CHC and Section 117 Individuals, a legal and practical insight for ICBs specifically, where we hope to provide you with some tools to help set the record straight. I'm Leah Selkirk. I'm a Principal Associate in the Health and Care team at mills&reeve. I act for NHS and private sector organisations, and I specialise in Mental Capacity Act and Court Protection matters, investigations and inquiries, and also public law matters involving judicial review. I'm joined today by Saara Idelbi, who is a barrister at 39 Essex Chambers, and Saara specialises in administrative and public law matters, human rights, court of protection matters, inquests, inquiries, and healthcare civil claims. I'm also joined by Kieran Leahy, who's a senior associate in the mills&reeve estates, trusts and will disputes team, who has a wealth of experience in acting for ICBs in contentious court of protection matters. Today, we're going to be exploring the common misconceptions around funding responsibilities for CHC and Section 117 aftercare funded individuals, with a particular focus on disputes that can arise between ICBs and local authorities. We are seeing more and more cases, particularly those arising in the Court of Protection, where an individual lacks capacity to make a specific decision, that are giving rise to these disputes. More so where local authorities seemingly being of the view where an individual is CHC funded, their responsibility to that individual ends and everything falls to the ICB. We're also seeing issues regarding tenancies, so involving arranging capacity assessments and the ultimate signage of tenancy agreements. And the big one in particular is finance issues, so arranging and managing financial affairs for an individual where they lack capacity, or again, arranging the relevant capacity assessment to determine that. Our agenda this morning is pretty packed for a 1-hour session. In terms of housekeeping, a copy of the slides and the link to the recording will be sent to you following the webinar. You'll also receive a pop-up link as soon as you click end webinar. Please do take a couple of minutes just to complete that form. It does mean a lot to us in terms of improvement going forward. And anything that you can obviously highlight, anything that we've done particularly well in this webinar as well. So as I say, it does help us in the future. Please use the Q&A box rather than the chat box for questions, and we will get to as many of those as we can within the time that we have. We are set to finish at 10:30 this morning. Moving on to the agenda proper then, Saara will be covering what the law says and doesn't say specifically to continuing healthcare and Section 117 aftercare. I will be looking at some practical guidance, particularly in respect of dispute handling. Kieran will be looking at a case study where the action taken led to the success for one of our ICB clients. To complete the circle, Saara will then be looking at the legal routes or challenges available if other dispute resolution processes have been exhausted. And finally, and hopefully, as I say, we will have some time for some Q&As. So over to Saara first. Can you tell us what the law says and what it doesn't say, Saara?
Right, well, welcome everyone, and thank you so much for inviting me, Leah, to speak on this issue. I really hate to be the bearer of bad news so early on this Tuesday morning, especially because you've come here for a talk about setting the record straight, and the news I have for you is that unfortunately the record really isn't straight. So why on earth have you come here on that promise? And this is where I get to give you a little piece of good news, because you come here for us to empower you to counter any suggestion by anybody else that the record is straight with one phrase: it's fake news. And what we've got here, we've got the best news, got the greatest sorts of news for you to be able to deal with those sorts of suggestions. And Leah's already outlined the problem. And in our experience, when you have a local authority suggesting that they are completely absolved of any responsibility for a particular person, that will cause some real difficulties for that individual. So the first part of my talk is going to deal with CHC, and then I'll move on to section 117. Next slide, please, Leah. Right, before you groan at me for sneaking in a history lesson into a legal talk, possibly about stuff you already know about, let me explain. It seems to me that it's really important to understand where CHC came from in order to understand how to deal with the challenges that are coming up at the moment, and helps us focus on the intention of CHC arrangements. So as we know, the NHS was created in the post-war era, 1948, and so came an era where there were a lot of people who were in hospital receiving long-term care. And we can typify that as elderly people with a lot of physiological issues, those with learning disabilities, and those who come within the mental health estate. And obviously with the NHS's creation, healthcare was free at the point of use. And so the care that individuals who were receiving long-term care in hospital was free in all respects, their medications, their food, their accommodation. But if they were not in hospital, the NHS didn't fund those services. And so it was noted the high numbers of people who were living in hospital, and efforts made through the 60s into the 80s to try and move those people out of long-term hospital and into the community. But with that change brought a shift in responsibility for funding and obligations on local authorities to arrange services that might have been available for the individual in hospital. And to some extent, that creates a degree of inequality for the individual and some complexity on how you divide that point in time. And those are matters that I say that we need to think about, because when you understand the context of support for things like management of finances, it helps to understand why we would say that that doesn't extend currently. Acknowledging this problem, in April 1993, you have the National Health Service and Community Care Act coming into force, which required local authorities to take the lead in assessing needs for those who required community care services. You'll hear from me later that that has been amended now to focus on section 117, but knowing that it extended across the board gives you a bit of a flavour of what the obligations were for the local authority and how it pushed that forward. And so came a successive number of different types of guidance issued by DHSC to try and clarify the line between what duties were owed by local authorities and what duties were owed by the NHS. Much of this discussion at the time revolved around responsibility for nursing care, and then a little bit later, accommodation, which I'll come to shortly on the cases about that. But now we're going to turn to the fun stuff, the legislation. Next page. And before I go through all of this, I want you to think about what I'm going to discuss through that lens of what CHC had come to fill as the gap. You'll be relieved to hear that I'm not going to read out every provision on this slide that is relevant to CHC. I've already mentioned the successive guidance that tried to clarify the borders between health and social care, and you would think that maybe the concept of what counts as health needs or social care needs would be easy to pinpoint, given the gravity and importance of those particular matters, and to help you understand what they're meant to be doing on their day-to-day job. But no, because the law isn't like that. The Health and Social Care Act 2008 defines what health and social care are in the context of the framework for the CQC, but for the rest of us mere mortals, we'll have to figure it out through the course of looking over a number of different sets of provisions, legislation, policies, etc. And that's why the law is both funny and frustrating. On to the next slide, please, Leah. So I want to take a quick look at some of the provisions a little bit more closely. I'll put up here Regulation 21 of the 2012 regulations, which defines national NHS continuing healthcare, which is a package of care arranged and funded solely by the health service. And you've seen that I highlighted here to meet physical and mental health needs. I ask you to pause on that. We will come back to it. Below, you'll see the national framework, which Leah is going to go into in a little bit more detail, but in particular in paragraph 4, the reference to associated social care needs. Associated social care needs doesn't actually appear in the regulations or in the NHS Act. You might think that we would have tried to keep the phrases the same so that we can all understand how they match up. But again, that's why I say that any suggestion that this area is straightforward is obviously fake news. The astute of you will note that the 2012 regulations will have come after the NHS Act 2006 and well after the concept of CHC started to emerge in the 90s. CHC is not, in fact, a concept created by statute, even though the regulations refer to it. So where does it come from? And this is where I'm going to take you through some myth-marpling in the statute. So next slide, please. Here we have some of the provisions from the 2006 Act, and Section 1 imposes the duty on the Secretary of State to promote a comprehensive health service designed to secure the improvement in the physical and mental health of people in England and in the prevention, diagnosis and treatment of physical and mental illness. Section 2 gives the Secretary of State and NHS bodies the power to do anything calculated to facilitate the execution of your functions or duties. It's quite a large power. Having the power is not necessarily the same as using the power, but Section 2 is where the courts have accepted CHC funding has come from, essentially, where the power has grown from. And then on Section 3, you go to see that it imposes a duty on ICBs to arrange for the provision of care for people suffering from illness as appropriate as part of the health service. This is where lawyers tend to get nerdy and you think, my gosh, why have I decided to spend an hour with them like this? We're looking at the wording, promotion, arranged for. Those are indicators to us that what is required from health bodies is to achieve a goal, a system. The objective is broader rather than an individual operational delivery requirement, which is very different from the arrangements under the Care Act, because under the Care Act, over the page, the duty on a local authority is individual. And you can see from Section 18, the local authority must meet the adult's needs for care and support, direct and specific, to deliver those outcomes. That matters when you think about CHC, because we need to see what the individual outcomes the local authority are required to meet as the foundation to then understand what the system that's built around for CHC is designed to be in place. So you'll note when we come to some of the later slides that the case law suggests that there might be a gap between the two, and I do know that practice has emerged that there shouldn't be a gap in the provision of certain services, and I'm going to deal with that and how we interpret it shortly. But if we can turn to the next slide, it's helpful for us all to conceptualize the duties side by side. So this is what is required of local authorities as set out in Section 1.2, which is the wellbeing matters that the local authority have to consider, and you have to read that alongside Section 9 with the duties on an ICB, or the areas for which you have to arrange, so your functions. And you can see that personal dignity includes physical and mental and emotional well-being, protection from abuse and neglect. These are a much more expansive range of areas that the local authority are responsible for meeting. And they can meet it through a number of different ways, as you saw on the previous slide, but they are huge. Whereas by comparison, you can see on our list for Section 3, hospital accommodation, medical, dental, ophthalmology, nursing, other services for pregnant women, palliative care, and at the bottom, again, bold, appropriate as part of a health service. And I dwell on that for this reason. As Leah explained, the problems coming up are because of the idea of the transfer. A local authority may think, these are our duties and now they're yours, handing over the baby. And that's not the right way to look at it. It seems to me that the right way to look at it is that the whole baby sits with the local authority, and then CHC takes over parts of that baby's care. And that's consistent with the practice idea of there being no gap in provision, because if CHC doesn't take it, it still stays with the local authority. So continuing with my analogy, if the local authority hold the baby, CHC says, right, so we're responsible for nappy changes, taking to medical appointments, doctor's appointments, but you still have to take them to school. And that's what it's helpful to look at how it was at the beginning. And I say that that's the right way to interpret it for these three reasons. Firstly, let's look at the wording on Regulation 217 in the 2012 regs. And the two sub-paragraphs are really interesting because it says your assessment of what is a primary health need comes down to what is more than the provision of accommodation under which the Social Services Authority is under a duty to provide, or is a nature beyond which a Social Services Authority, whose primary responsibility to provide, could be expected. The thought process all starts with what the local authority must provide and how does a person's need go beyond that. And this is a facet of the assessments that I rarely see articulated in DFTs that I have read, obviously sample bias, so I can't speak for everyone, but highlighting and pinpointing what aspect of the person's needs go beyond that is really helpful in crystallizing what CHC is stepping in to assist with, especially when it comes down to, as Leah will discuss, the local arrangements that you are putting in place. And so one of the cases, Grogan, that I'm going to come to, it was accepted at the time that health bodies' responsibilities are not necessarily defined by the end of the local authority's responsibilities, but it means that they're not interchangeable. You can't just swap them around. Secondly, history. And remember, I asked about suggesting we look at everything through the lens of where CHC came from. When a person goes into hospital for care, short or long term, what is the hospital truly taking responsibility for? You would probably be a bit surprised if the hospital started managing your finances whilst you were in a coma, wouldn't you? Imagine the circumstance where you have a billionaire who then suffers a serious injury and cannot manage their exceptional wealth. Can it be said that the management of their complex personal finances is appropriate as part of a health service? Going back to the previous slide. Obviously not. And again, it crystallizes why we need to think about matters through that lens. What is CHC there for? And this brings me to number 3, the case law supports my interpretation in my view. And let's go to the next page. So you'll note that the first case in this list predates all of the legislation that I've taken you to, but it's important to know where to draw the line because it's still referred to as the leading case in the area. It's still the case that's referred to in the national framework. And Cochrane actually concerned the closure of a health facility where the health body were trying to transfer the individuals into the local authority's care, and the complaint was made that that was an unlawful decision. That was about the concept of nursing care. And so where nursing care is just merely incidental, didn't come within CHC. That was obviously overtaken by what was the Health and Social Care Act 2001, but is now the Care Act, so that all local authorities are responsible for arranging nursing care in that way. But it highlights that not every aspect of a person's care is necessarily going to be within the health services requirement to provide. Then you look at WAPLs, which is about accommodation, and the claimant there had PTSD, considered that she needed larger accommodation to manage her needs, but wouldn't move until the CCG confirmed that it would fund the increased cost of housing, which the CCG refused to. And the court concluded that the CCG was entitled to say that it was not a reasonable requirement for them to provide accommodation funded by the NHS. It's important to highlight, I should say, in fairness, that actually the local authority were not involved in that case. It was an argument between the individual and the CCG, something I will discuss a little bit more when we talk about legal routes of redress. But what both sorts of cases highlight for you is that these are provisions that could arguably fall within the remit of health or the remit of social care. So before the 2001 Act, nursing care could be part of social services delivery or part of the NHS. And the overlaps between those, because a nurse might provide care and taking somebody to the toilet, it's not necessarily a clinical aspect of their job, and that has caused problems in the past. Accommodation, similarly, is something that all persons need, but specialist accommodation can be considered a health requirement. None of those cases concerned a debate over what might obviously be within the remit of health or social care. And that's something I'm going to come back to later again when I talk about the legal routes of redress. But what that says to me is that we are starting to see that conceptual shift as we are battling to understand those lines. And Leah will come to the practicalities of policies and agreements and structures in place to make sure that you are not trapped in it. Because in the third case that I've got in this list, Forge Care Homes, which is about trying to divide the responsibilities of a nurse, the Supreme Court said that there is nothing unusual in the NHS defining the limits of its responsibilities for itself. And courts have normally respected those decisions, subject only to challenges on conventional judicial review grounds. So leaving that for CHC and go through section 117 a little bit more quickly because I'm conscious of the time. You'll be aware section 117 is a joint duty to provide aftercare services for individuals who have been detained under the Mental Health Act, and the individual cannot be charged for the aftercare arrangements. It doesn't permit local authorities to fund nursing care, so that's consistent through CHC and the Mental Health Act. But unhelpfully, it doesn't specify who must fund what. And I've got to say that when I sit as a judge part-time in the Mental Health Tribunal, the practicalities of that can be really difficult. You'll often have a social circumstance report writer, either from the health body or from the social services body, and they will always say something along the lines of, well, that's within the other side's remit, and so I don't know what the provision is going to be. Really difficult and important, therefore, for roles to be dictated in the documents. In 2024, the discharge from mental health inpatient settings statutory guidance was issued, and at Annex B, there is the guidance on how budgets and responsibilities should be shared between ICBs and local authorities. The guidance states that the ICB is responsible for commissioning and paying for the NHS element of an individual's Section 117 aftercare, which must be determined in accordance with the Who Pay rules. This is statutory guidance, but it was also issued by DHSC. So you might get into a little bit of hot water in suggesting that there might be some tension between the NHS Secretary of State's dictating the limits of local authorities' funding duties. But that hasn't been discussed as yet, and there are no cases about it. It will come down to that collaborative working. It does remain the case that under Section 47 of the National Health Service and Community Care Act that I referred to earlier, this is the 117 requirement to assess on the local authority, and from there working forward. So that is the question that brings us to those policies, arrangements, the practicalities, and a sensible point for me to hand over to Leah.
Thank you, Saara. So moving on to some practical guidance then for ICBs. Firstly, I would, it's important obviously to check your policies, and we'd hope you'd have certainly the ones that are on the screen in place, which would involve CHC policy, Section 117 policy, and dispute resolution policies as well, which I'll come on to in more detail shortly. Specifically for CHC policies, obviously ensuring that they are compliant with that national framework guidance. In particular, as Saara's just set out for us, for CHC eligibility, somebody must have a primary health need, meaning that the NHS is responsible for commissioning a care package that meets the individual's assessed health and associated social care needs that have arisen as a result of disability, accident, or illness. And it's this associated social care needs that brings about the disputes, because there's no clear-cut list on what is to be considered as an associated social care need. But where we apply the CHC framework practically to this section of the webinar, I'd signpost you to the following paragraphs within the framework. So specifically, paragraphs 50 to 52. So they attempt to assist us somewhat with health and social care. It confirms that there's no legal definition of the term social care need in the context of NHS continuing healthcare, but it does refer to the Care Act, which Saara's referenced, and that introduced the eligibility criteria for care and support. And that criteria includes managing and maintaining nutrition, maintaining personal hygiene, managing toilet needs, being appropriately clothed, and that list is fully set out, obviously, in those paragraphs. Paragraph 53 notably says that in the context of NHS continuing healthcare, a social care need can be taken to relate to the Care Act 2014 eligibility criteria that again is set out in those earlier paragraphs 50 to 52. Paragraph 294 states that the care plan should set out the services to be funded and or provided by the NHS, and that it may also identify services to be provided by other organisations such as local authorities, but the NHS element of the care should always be clearly identified. Again, so it's pushing you along the lines of the arranging the clarity between the statutory bodies. Paragraph 315 states that meeting health and associated social care needs could include a care package including accommodation, if that's part of the overall assessed need, equipment, routine and incontinence, laundry, daily domestic tasks such as food preparation, shopping, washing up, bed making and support to access community facilities, etc. However, importantly, also states that the NHS is not responsible for funding rent, food and normal utility bills. So if we look at the practice guidance as well, so paragraph 56.6 states that local authorities should be aware that they may continue to have responsibilities under the Care Act 2014 to those in receipt of NHS continuing healthcare. So this notion of washing hands of individuals assessed as being eligible for CHC will not wash. Local authorities cannot lawfully meet the needs by providing or arranging services that are legally the responsibility of the NHS. But therefore, it's important, obviously, in deciding what services to provide or arrange, the local authority will need to take into account the services that are responsible of the NHS to provide or arrange, so either through continuing healthcare or as other NHS services, so community services, for example, or funding nursing care, etc. The key bit is that they may also continue to have some responsibilities for those in their own homes eligible for NHS continuing healthcare, where services needed are not ones that the Secretary of State requires the NHS to provide. Unfortunately, that doesn't take us much further with the very common issue that we see arising on cases, particularly involving the management of finances, which we've alluded to throughout so far. In terms of Section 117 policies, the Health Service Circular HSC 2000-003 and the Local Authority Circular 2000 subsection 3 says that social services and health authorities should establish jointly agreed local policies on providing Section 117 Mental Health Act aftercare, and policies should set out clearly the criteria for deciding which services fall under Section 117 and which authorities should finance them too. The duty is joint in the sense that the authorities must collaborate and plan together when providing or arranging to provide services that come within the scope of their health or social care responsibilities. And that I touch back on what Saara said about the latest statutory guidance that's come out recently as well. Section 117 aftercare can include the provision to accommodate if that is a need arising from the person's mental disorder, and also helps to reduce the risk of deterioration or readmission, I should say. And there may also be Section 75 arrangements in place whereby resources are pooled between the ICB and local authority and functions delegated. So that there's one single provider of services. We have seen those, albeit we would reiterate again that where you have got a Section 75 arrangement, there is a clear policy in place about how that works in practice. Ordinarily, my experience is that with Section 117 aftercare cases, local authorities tend to adopt a lead function. Again, I think that comes from the requirement to assess there. But I am yet to see a policy that explicitly states that or sets out kind of the guiding principles or the local agreements in place. There may obviously be arrangements in place depending on your local working practices, and obviously better still, we would strongly encourage that is drawn up into a policy, an agreed policy between partners. There is no guidance on the division of funding between the ICB and the local authority for Section 117. It is a joint duty in law, and it is presumed to be a 50-50 split unless it's stated differently. Looking at dispute resolution, just very briefly, because I'll come on to this in more detail, you should have a policy in place. And if not, we would strongly encourage that is something that you do work towards with your partner agencies. As we all know, ICBs are undergoing a huge overhaul at the moment in terms of the cluster arrangements, which are very much in process. And it might be that one of your cluster ICBs has a policy in place that sets out these arrangements that works well, and that can obviously be reviewed and adopted more widely. So I would suggest that as part of those cluster arrangements, there are reviews of policies ongoing where some policies may be better in some ICBs that can be utilised for other areas where they are working well. In terms of guiding principles, on the next bullet point, I would probably emphasise this as being more fundamental principles. So it says there, obviously, no gaps in care. So paragraph 232, 234 and 239 of the National Framework sets out that individuals must never be left without appropriate support while disputes between statutory bodies about funding responsibilities are resolved. And there has to be collaboration and commitment between statutory bodies to work in partnership in a person-centred way. And we would say, obviously, that this is essential to sustain joined up, efficient and effective services. And ultimately, ICBs must cooperate with organisations within their footprint, which is obviously going to be a much wider footprint, and are encouraged to establish joint working relationships, joint working arrangements with those organisations to meet the health needs of the local population. That includes collaborative working with local authorities, with statutory care responsibilities, whose areas falls wholly or partly within the area of the ICB. Just looking very briefly at informal routes, so obviously MDTs or meetings between teams, any local arrangements that you have in practice. It may be that they aren't written down. We would always strongly endorse that they are written down, but sometimes this is just how it works. Escalation routes, which I will come on to more in more detail next. But obviously always documenting those requests for assistance and making sure that there is that evidence base and evidence of those meetings that do take place and that any actions are recorded or any disputes or areas of contention are recorded as well. So moving on to dispute resolution processes just in more detail. So usually we see dispute resolution processes looking similar to that is set out on the screen. And we would expect any policies to obviously set out your own timescales and procedures with those. Usually that dispute resolution process has gone through a joint review. You can't essentially join up to a dispute resolution process unless both parties are in agreement that that is how you're going to sort it out. But the key is obviously to keep evidence of each stage and discussions that do take place, and obviously any decisions that are made. The national framework is helpful, whilst it is CHC focused. It is helpful in terms of applying that across the board to Section 117 cases as well. But particularly paragraphs 228, 232 and 234. Paragraph 232 sets out the fundamental principle that it's for ICBs and local authorities to minimise the need for interagency dispute resolution processes by following the national framework guidance consistently, by agreeing and using local protocols that clarify consultation duties and partnership roles, by promoting genuine partnership across all aspects of NHS continuing healthcare, ensuring eligibility decisions are evidence-based and accurate, keeping the individual at the centre of all decisions with a person-centred approach, and resolving disagreements early and informally wherever possible, handling professional disagreements professionally without involving the individual to support one side, and providing high quality joint training for health and social care practitioners. Again, it endorses that paragraph again, that individuals must never be left without appropriate support while those funding disputes are resolved. As I say, there's paragraph 233 and paragraph 234 there as well that provide some guiding principles on the dispute resolution processes around informal stages, formal stages in terms of escalation, and even referring the case for independent review or arbitration. As I say, we'd expect to see similar framework or a similar process for disputes arising from Section 117 disputes. And if there's no dispute resolution process in place, or if this has been exhausted, the next step would be to start on a more legal footing. And that leads us to legal correspondence, which can be a prelude to more to formalising a more legal route, which Saara will come on to shortly. But initial correspondence can be sent, setting out the statutory provisions as the position is that Saara has laid out, and also the responsibilities and duties of both the ICB and the local authority. This then may lead to formal pre-action protocol correspondence, which is formal legal correspondence sent in advance of initiating judicial review proceedings, again, which Saara will come on to. I'm now going to hand over to Kieran, who's going to tell us about his successful case study.
Thank you very much, Leah. As Leah concluded there, in terms of the informal and formal correspondence can be very helpful, and I think this is very much an illustration of that and how that can be used. And I'm sure everyone on this webinar is aware of it, but in the context of P's finances and financial resources, generally speaking, there's two broad roads you can take, and it may very well be that you ultimately end up taking both. But one is for the appointment of an appointee. That's a far more straightforward process. That's usually an application to the Department of Work and Pensions. There may be an interview, and then that allows that person to manage P's statutory benefits, apply for the benefits and utilise them. Or the alternative route is a deputyship, which is far more wide-ranging. It involves an application to Court of Protection, is therefore more expensive as an application, but also more involved. But it gives far more wide-ranging powers to manage P's financial assets more generally. The crucial point to note here is that there's no power on the part of the Court of Protection to compel anyone to act as a deputy. You must volunteer to do so effectively, whether that is a local authority, whether that's a panel deputy, whether that's a professional, or whether that's a lay person such as a family member. And what we're very much seeing is that where individuals are CHC funded, the local authority very much say that's a role for ICBs to take. It's nothing to do with us. And as Leah says, it's very much that they're looking to push back towards the ICBs rather than taking on roles in respect of P's financial assets and financial resources themselves. And this case study is very much just about how we've looked to engage with local authorities to highlight their duties, their obligations, their responsibilities, with a view to encouraging them to take an active role in respect of P's financial resources. So if we go through the case study, and it's very much on the slide, but we had an example where P was in his early 30s, he had a hypoxic brain injury, was non-verbal, unable to communicate, also suffered from epilepsy, was clinically complex with a very high level of care needs, and crucially was continuing healthcare funded. If we turn to the next slide, thank you. So in terms of P's family, historically, P's family had been involved historically. He had a sibling who had visited often, and crucially, P's sibling had historically helped out with his finances. He had access to his bank information historically. It was unclear when we came on board as to whether they still had that access or not, because there was no visibility on P's finances at all, and I'll come to that in a moment. There was also an aunt who may have had historic contact, but there had been no recent contact. And that was a crucial point, and that's the sort of thing that we actually see quite a lot in these instances, is that family members are often either not in the picture, or they don't want the responsibility of acting as someone's deputy or appointee, and instead simply say, well, we're not going to get involved. And then the question becomes, well, who can act? Who is the appropriate party to act? And it's very much our view, and the view that we've been looking to put forward is that actually, and I think as well, possibly very much the court of protection's view as well, that it's for the local authority really to act in those circumstances more so than the ICB for the reasons that I'll come on to in the next few slides. If we turn to P's financial position, when we came involved, very little was known. And that's quite common, because the ICB, and any ICB, is not ordinarily going to have a great deal of visibility over P's financial assets, given that's not their responsibility. Their responsibility is not managing P's finances for the reasons that Saara said earlier. And so it is typical to have very, very limited visibility and transparency over what P's financial resources are, whether that's in terms of liquid or other sources of capital or income, whether that may be statutory benefits, whether that may be possible inheritances, maybe that may be money in their bank account, whatever it may be. What was clear, however, is that the lack of transparency and the lack of anyone having access to financial resources was having adverse effect on P. And in particular, P didn't have any access to whatever money he had, and so was unable to afford basic amenities such as toiletries, pajamas, clothing. And P should have been receiving statutory benefits. That much was clear. And it was unclear as to whether either A, those statutory benefits had been applied for and P just simply couldn't access them, or if no application had been made at all. And so that brought us to this position where someone had to do something. Someone had to take some steps to ascertain what P's financial position was, what his financial resources were, and to start utilising those for P's benefit. But the question arises of who does that, who carries out that role, particularly when, as I mentioned earlier, we're in the position where the Court of Protection cannot compel anyone to act as a deputy or to manage someone else's financial resources. And so if we go on to the next slide, so what we did, as Leah said, there is a lot of benefit in correspondence, whether that's informal correspondence, setting out duties and obligations and setting out the position, including sometimes the factual background and highlighting how many efforts we made to engage, or whether by means of a more formal correspondence, for instance, by way of a letter before action. But what we did is we looked to engage with local authority and to set out our position quite clearly in correspondence as to why we considered that they were the appropriate party to act in terms of managing P's finances, whether that was by way of an appointeeship or whether by way of a deputyship. And actually, having an appointeeship as an initial role can actually sometimes be very useful, because if you don't know what P's finances are and what his financial resources are, then actually there may be no need for a deputyship. It may be that he has very limited capital, and it may simply be that all it is really is applying for statutory benefits and utilising those on P's behalf, in which case an appointeeship, it probably does the job. But without that visibility, you don't know. And so it's about getting the local authority on board to assist with that and take that cooperative approach so as to be able to act in P's best interest. And so what we did is we wrote a letter and we highlighted the factual background and the steps which have been taken historically to bring safeguarding concerns about P's finances to the local authority's attention, and to make clear that this isn't that we're popping up at the 11th hour and asking you to do X, Y, and Z. Actually, we do have very real concerns about P's finances. We do have very real concerns that there could be financial abuse, for instance, because we don't know, we don't have any visibility on what is happening with P's finances, with P's bank account. And so there are concerns as to what the present position is. And we've raised these concerns to you, and therefore we think that they invoke, say, your safeguarding duties and things like that. And I'll come on to that in more detail under point 3 on this slide. But it's about highlighting that to them and highlighting that chain, that the ICB have taken every opportunity to bring this to local authorities' attention, to highlight it to them and to say, look, we think you need to be doing something. And if nothing else, that gives the ICB a greater degree of protection by showing to the court, actually, we've done what we could. It's not our role to commission financial services, it's our role to facilitate financial services. But we have flagged it to the right people who we think should be taking it forward, and that is what we've done, and that's how we've looked to safeguard P. And that brings us on to point 2 here, which is to clarify the nature of the ICB's duties pursuant to the National Health Services Act, and particularly the fact that the ICB's duties commission healthcare services. It's not to provide healthcare services themselves. It's not to commission financial services to manage someone's financial resources. ICBs simply aren't set up to do that. They're not geared in that way. There's no obligation and there's no real power to do that at all. And instead, so what we would say is that actually that demonstrates that it's not for the ICB to take these steps. Okay, yes, it might be appropriate for an ICB to flag concerns, but it's not for the ICB to then run off and be a deputy themselves when they're just ill-equipped to do so. They simply don't have the resources or the structure to do so. In contrast, a lot of the duties of a local authority are very much in keeping with a deputyship. Whilst it's correct to say that there is no statutory duty which says a local authority must act as someone's deputy, there are various duties which very much align with being a deputy. So, for instance, under Section 1 of the Care Act 2014, there's a duty to exercise a function to promote an individual's well-being, which includes social and economic well-being. There's a duty to prevent abuse and neglect. Section 2, there's a duty to take steps to avoid the prevention or delaying of development of needs. Section 7, subsection 2, again of the Care Act, a duty to cooperate with ICBs for the provision of health services. Under Section 42, if there's safeguarding concerns or concerns of the risk of abuse or financial abuse, again, local authorities have duties. And under Section 47, there is a duty to protect the property of adults who are being cared for away from home. Now, again, whilst that is not a duty to act as a deputy per se, they are duties that arguably are fulfilled by the role of acting as a deputy. Arguably, being a deputy is the mechanism by which local authorities should be fulfilling those duties. And that's the point we've looked to make. And that's a point that when we come on to point 4 of this slide, the Friendly Trusts bulk application, is a point that the Court of Protection itself made. It's a really, I think, helpful case for ICBs. And even just to quote from it, paragraph 65 to 70 are the very key paragraphs. And Section 65 says that nowadays some local authorities are at pains to point out that the 2005 Act, that's the 2005 Mental Capacity Act, requires deputies to consent to being appointed, and so they cannot be required to take on a duty. Paragraph 66, that is true, but such statements need to be understood in the context of legislative history. It then goes on to speak about Section 48 of the National Assistance Act, which is now being incorporated within Section 47 of the Care Act, and the fact that there is a duty to protect the property of adults being cared for away from home. And so the Court of Protection very much reached a conclusion at paragraph 69 that although local authorities often say that they have no statutory duty to act as a person's deputy, it can be seen that this is something of a simplification. Deputyship was only ever a means by which a local authority could fulfil a statutory duty. And so at the paragraph 70, it then goes on to say that local authorities have a statutory duty under the Care Act to protect an incapacitated person's property in certain circumstances, and applying for deputyship may be the only practical means by which they can discharge that duty unless they outsource the work. And so again, it goes back to that point. Whilst there is no duty to act as a deputy, arguably deputyship is the mechanism by which they fulfill their duty, and therefore that is why the local authority is best placed to act in that role, and that's why it is appropriate to look to the local authority in the first instance to act in roles where there are no lay persons who are willing to act, where there isn't clarity as to whether there are sufficient financial resources that are such that make it appropriate for a professional to incur costs and act. And so that is why I think there is very much a scope to put pressure on the local authority, even if there isn't that means of saying, well, we can force you to do so by way of a court protection application. And I think there is another case as well, which I'll very briefly comment on, which is re-M, N, and the case O&P in 2013, in which the Court of Protection stated in terms of their order of preference for a deputy, it is P, spouse or partner, any other relative who takes a personal interest in P's affairs, a close friend, a professional advisor, then a local authority social services department, and then finally a panel deputy as a last resort. So again, the Court of Protection is saying that it is the local authority they will often expect to act in that role, where it is not suitable for a professional or a layperson to act. It's not saying it's appropriate for the ICB to act in that role. And so again, I think it's about making these points clear that if nothing else, the court does expect them to act in that role. And there are legal routes that can be taken if they refuse to do so. And I won't comment on those because I think Saara is going to speak on those in more detail in a moment. But there are means of putting pressure. And as I say, it is just pressure at this stage. It is just correspondence. We can't force them. But you do get situations where local authorities are willing to engage and they do appreciate that actually, yes, we are best placed. And therefore, for that reason, we will either take on an appointeeship or look to take steps to progress a deputyship application. And if we go to the next slide, in this instance, this was very much one of those times. They acknowledged that the local authority responded to our letter in this instance and acknowledged that there was a lack of detail in their safeguarding reports and said a Section 42 inquiry would be completed in due course. I think in this instance, we were probably aided by the fact that there were concerns as to whether there was financial abuse or not, and the local authority probably hadn't covered themselves in glory in terms of carrying out those responses, which may have made them more amenable to engaging with us and saying, okay, we'll do that now and we'll take steps to manage Peace financial resources in the interim. And they very much, they kept to what, as you would probably expect, they denied that they were required to act, and I wouldn't necessarily expect them to take a different stance, but they did agree to take on the role of an appointeeship in order to safeguard Peace financial position. And they said that subject to that, they would then consider applying for a panel deputy where subject or appropriate to do so. And crucially, they would incur the costs rather than the ICB of doing that. And that is progressing. An appointeeship that is now in role. And it will now be for them to decide whether it is appropriate to make an application for a panel deputy or a deputyship of any other form, whether that's the local authority acting or not, or whether actually they think that it's the case that an appointeeship is enough without the need for a deputy. But it is evidence that actually there can be instances where the local authority are willing to engage. They are willing to see that there is quite a body of authority that suggests that Court of Protection look to local authorities in such circumstances. And I think certainly for the price of a letter, for the cost and the time of sending a letter, it's certainly worth taking that as an initial step.
Thanks, Kieran. Moving swiftly on, because I am conscious of time. So finally, Saara, can you tell us about the more formal legal routes after the dispute resolution processes have been exhausted, please?
Absolutely. I'll try and take this relatively quickly, but what I wanted to pause to say is from what Kieran said, it is really useful also to highlight that in Section 8, the earlier slide of the Care Act, meeting a person's needs for a local authority includes a number of mechanisms, but can include others. And as Kieran says, deputyship can involve being responsible for the arrangement of COP3 assessments for testing whether or not a person has capacity if they have assessed that there is a need in that area. What you probably have picked up from some of the cases that I referred to and in our discussion is that local authorities tend to be the claimants in judicial review cases and seem to be less shy in challenging health bodies, CCGs and now ICBs in the decisions, but rarely do you see the other way around. And I thought that was quite a curious instance, because it does highlight that judicial review is the right mechanism and that you shouldn't shy away from it if there is a genuine issue that your informal routes have not been able to resolve. What you'll see from this list is no reference to the Court of Protection. The Court of Protection can be a useful framework to apply pressure, but it doesn't have the jurisdiction to determine the remits of funding responsibilities, even if it is tempting to roll those up. So judicial review, for those of you who don't know, it is the mechanism through which you can challenge a decision by a public authority for being unlawful for a variety of reasons. And I think it's helpful to highlight the Kensington and Chelsea case. I referred to it earlier. It also relates to one of the questions that I think we've seen in the Q&A. That was a case earlier this year where the local authority challenged the then CCG's refusal to fund an individual specialist placement when it was a child, in fairness, so there are some nuances there, but where the child had some significant behavioural issues. And the argument was that essentially the delivery of the PBS plan was not really social care because it was necessary for the person's health needs, and the court just didn't accept it. It actually concluded that the fact that social care staff were implementing a PBS plan didn't convert what was essentially a social care into a healthcare need. Further, the fact that the care is of a therapeutic benefit doesn't automatically make it healthcare. And so what we can see from that is, and as I referred to earlier, an objective of moving or colouring social care responsibilities as health responsibilities. You will always eventually be able to connect something to a healthcare benefit, but that doesn't mean it is a healthcare need. And that is why it is important to be able to challenge a belief that something has become a healthcare need. More often than not, the correspondence that both Leah and Kieran have referred to will resolve some of the issues, because nobody wants to spend money in judicial review. The courts have already said multiple times that they don't like seeing public authorities squabble over money in front of the courts. Everyone will bear that in mind. But it has to be an option that is on the table, because you cannot plan a strategy without knowing what your end goal is. What is your walkaway point, so to speak? Where is the end? And so judicial review is really the main area through which you should consider challenging decisions. It is a generally non-evidence-based process. You put in the application to ask for permission from the court to challenge a decision, and it will go on legal submission. So they do have to be legally coherent, and that's where the policies, the correspondence, all of the efforts that you've made to resolve the issue becomes vital. I'm just going to have a quick mention of restitution. Restitution is a very novel concept. The case that I've cited there, Surrey County Council and Lincolnshire CCG, concerned the refusal of the CCG to assess an individual for whether or not they were eligible for CHC funding. Later on, the CCG accepted that 2 instances where they refused were unlawful. That was the backdrop. By the time it got into the civil court, it had been accepted that there had been unlawful conduct. And that was a huge part of the reason why the court said, happy to deal with the restitution claim. If you have a dispute over who is responsible or unlawfulness, that is not the right route. It is going to be quite a difficult route. So I would say restitution claims, 1 out of 10, would not recommend. Judicial review is the way to go after the informal routes. And finally, as a quick nod to redress IP, you'll know in the context of Section 117 that if there is ongoing squabbles about aftercare that prevents the discharge of a person from the inpatient setting, that person is entitled to bring a Human Rights Act claim against the authorities because they have been unlawfully detained in much more extreme or restrictive circumstances than had those issues been resolved. Why I've referred to this is that if you are confronted alone with the claim by P, there is scope, if you are in dispute with the local authority, to bring in the local authority into that civil claim. And sometimes that can unblock it as well, because it will become quite an expensive process. Civil claims involve much more involved procedures and ultimately much more expensive ones. I'm sorry, that took me a little bit longer than I had hoped, but that brings me to the end of legal challenges and to 10:30. Leah.
Thanks, Saara. Yeah, I'm conscious that we're probably too far gone for questions and answers, so we'll have a look through the list, and I have had a quick look, and there are a lot of specifics there that we'd need to know a hell of a lot of information more about to be able to respond, but we'll do a recce of those and we can contact the relevant person in response to their answer. But yeah, I'm afraid we've just simply run out of time, but I hope that these sessions that we've all ran have at least tried to answer some of those questions that have appeared in the box. So I just wanted to thank you all for your time today. I hope you have found the session useful, and it will hopefully stand you in good stead for those tricky conversations where these issues are arising. If you do have any other questions, you can contact either myself or Kieran. Our details are on the screen. As I said, once you click exit, you will be prompted to complete a feedback form. Please do take a couple of minutes just to complete that. It really does help us. I would finally like to thank my co-hosts, so Saara and Kieran. Thank you ever so much for your time this morning. And yes, I hope you all have a lovely Tuesday. Thank you very much, everyone.
Have a lovely Tuesday.